Assalamualaikum warahmatullahi wabarakatuh. Before we show your video, let us introduce ourselves. My name is Awal Ali, as a judge ICJ.
My name is Elsa Putri Utami as a judge.
My name is Patricia Citra Dewi as a judge ICJ.
My name is Kusajati as a judge ICJ. My name is Rizky Aulia Jarif as Indonesia.
My name is Lukiana Salsabila as Indonesia.
My name is Hanifa as Indonesia.
My name is Muhammad Rizky Septiadi Santoso as Australian.
My name is Marix Rusnulatima as Australian.
My name is Viradina Maharani as Australian.
Good morning. Today, Sunday, 6 December 2020, international case trial concerning of the dispute over ownership of the Ashmore and Cartier Island dispute will begin soon. The panel of judges will enter the courtroom. We would like the attendees to stand up.
Well, please be seated. The sitting is open. The court meet today is to hear the oral pleadings submitted by Indonesia as the applicant. In the case concerning of dispute over ownership of the Ashmore and Cartier Island, Indonesia versus Australia, I now call upon the applicants to give their statement to the court. You have the floor, sir or madam.
You.
Thank you, Johannes, for your time. First, let we see the map of First, let we see the map of Kupang Regency and Rotendao Regency. Lines. The red line border of Indonesia territory and Australia, it shows that Ashmore is lies far in north of red line, and there's in territory of Rotendao entity or Indonesia. This map is territory of Dutch Indies Netherlands. So, all the argument from Australia that said the island is British property and the transfer to Australia is doesn't true, because distance from the island to Ashmore is 140 kilometers. Next, we see the map of NTT province and parts of northern Australia. This map shows the Ashmore is Indonesia's. Look, the red line border is lying in south of Ashmore. And next, we see the original map of Australia in the Dutch East Indies period. In this map, if we look Australia's northernmost border isn't included in Ashmore. Little island in northernmost Australia is just group of little island and near from Bougainville Headland, Londonderry Headlands, and Melville Islands. With this map, Australia can declare about Ashmore is the territory of British since 1878. That transfer for Australia isn't true. Then, if we look to the map of Australia in the world map, especially Western Australia, whose area 920 square miles, and North Australia, whose area is 500 520.280 square miles. On the world map published Hammond Standard World Atlas, copyright MCMLXXIX by Hammond Incorporated, Maplewood, New Jersey, printed in USA. It turns out that the Zen Island cluster, or Ashmore and Cartier Island, is not part of the Australia Territory. Furthermore, on the map of Western Australia and the Northern Territory, it turns out that Zen Island, or Ashmore and Cartier Island, are not included in the map list or are located outside the territorial boundaries of Australia. This means that it is through a group of Zen Island or Ashmore and Cartier Islands could reef, including X region. This is the map of Australia Coral Island entitled Coral Sea Island Territory. In this map, Ashmore isn't there in map list or lies out border Australia's territory. This means that Ashmore Cartier Islands Coast is included of ex-territory Dutch Indies colony, which is the part of Rote Island or Indonesia. Next is Australian engineering map. This is an unilaterally engineered map of Australia after 1974 MoU, which contradicts the Indonesian-Australian maritime boundary as in the original Dutch and US Indies map, which are considered invalid. The boundary line of the water is not straight when it reaches the Zen Island, and is made a semicircle to the north to block the Zen Island from becoming the property of Australia, and contradicts the 1982 UNCLOS regarding the boundary lines of interstate waters. If the dashed red line is pulled straight and merged, then it is clear that the same-shaped group still enters Indonesia, but because the line is made a semicircle to the north to block the Zen Island to enter the Australian territory, and it is not legal and needs to be fought back by Indonesia. Furthermore, when viewed in the new map, engineered by Australia unilaterally, there are three types of boundary line markers, namely, first, the slanted lines in the box, or area of fishing, indicate the zone that allows traditional Indonesian fishermen to find fish and marine life. Second, red lines dotted, or professional fisheries line. When viewed on a map, the intention of make a half circle to the north is to block St. Island belongs to Australia, in which case the making of this semicircular line contradicts UNCLOS 1982. Then, if the red lines are made straight, then Pulau Pasir, then St. Island or Ashmore will enter Indonesian territory. Third, horizontal red line, or Indonesia or Australia's seabed boundary, contrary to the red line dividing Indonesia-Australia on the map of the Dutch East Indies and the map of United States. Thank you. Next, my partner is gonna tell you from history view.
Based on history, the first Westerner who discovered Rote Island in Entente province in 1522 was a Portuguese sailor named Antonio Pigafetta, who was one of the world's traveling Michael Hans, who named the island as Rote, according to the name of the traditional fishermen he met at Papela Rote Harbor, East Entente, which in 1778 or more precisely 256 years later from 1522, Captain Cook just discovered the east coast of Australia. Meanwhile, Captain Ashmore in 1811 or more precisely 218 years later from 1522, he just discovered the group of Pasir Island. However, if you look at who first discovered the Pasir Island cluster, namely the indigenous people of the Rote tribe in NTT, they had already discovered the Pasir Island cluster far before 1522 by a Rote community leader named Dato, who then named the island after his name. But later, the islands were better known as Solo Cake and finally Pulau Pasir, in which the group of islands is used as their fishing field throughout the year from generation to generation, and not as a residential island, but as a place of rest and shelter in a case of storm. Then also that this sand island has been navigated since a long time ago by almost all traditional fishermen in eastern Indonesia, especially those from Rote Island, Bugis Makassar, Madura, Buton, Alor, and Flores from generation to generation until the entire of Dutch colonizers in this archipelago. So, if it is seen from its history, those who actually discovered the Australian continent for the first time were people or traditional fishermen of Indonesian nation, and not people or Western nation. Then, if Britain now claims that it first discovered Australia and the group of Sand Island, and it claimed it as its property, it's not true. If we compare it to the years of the first discoveries as mentioned above.
Then the basis for claiming ownership of the same island that we have noticed of 1. The Dutch East Indies Government General Decree letter of 1751, which proved the Sand Island cluster was made 1400 years ago, the Rote people and Tete. 2. Fishermen have been looking for fish, other main other marine hazards of this island. 3. 161 graph of Rote people in for some island belongs to the Rote kingdom. The 15th century has been under the management of the Dutch. This can be proven through victims of Raja type or Coimbra on Sand Island, which was made when the king was not on the island. Furthermore, regarding the basis for the claim for ownership of Sand Island, 1 to 4 in the above demands, namely the registration letter for the Governor General of the Dutch East Indies, 1751, fishing, cucumbers, and marine biota by Rote fishermen, the existence of Rote people, and the inscription of the king Coimbra in Sand Island are of findings, and the Dutch East Indies government operation of Sand Island. According to the principle of international law, when final of paying on an earth continent is one on the way to gain sovereignty over the island continent. So it is associated the basic demands of the above. Indonesian has fulfilled the occupation of the Dutch East Indies on Sand Island, which is in the intention of Dutch Indies to apply sovereignty over Sand Island to concrete action, such as application of the rules on Sand Island is like giving permission to sail the ship to the same island and other rules.
Well, thank you. I thank the applicant. Is the respondent ready to give their argument against the applicant's pleading today?
Thank you, Judge, for your honor. So, here our argument about Indonesian claims. If the claim to ownership of an island or territory is based on historical claims, then China can claim that the island of Java and Sumatra, for example, belong to them, because in the past there were representatives of the Chinese emperor who visited the island in this archipelago.
And then in international law, claims of ownership based on historical arguments, traditional proximity, or geographical proximity cannot be accepted because they can be subjective. International law holds more evidence of legal effectiveness, such as the cases of Sipadan Ligitan Island, Miangas Island, and Bacek Island. Thank you, Your Honor. That's a response from Australia about Indonesian statement.
Okay, thank you. Does the applicant have no objection to the respondent's statement?
We accept the statement, Your Honor.
Okay, well, you have delivered your argument and statement. We have to discuss it for a moment. Thank you. The sitting will be postponed and will be resumed on 7 November 2020 at 7 p.m. with the agenda of the pleading hearing from Australia as the respondent, and the parties involved are ordered to attend the sitting without being recalled. I declare the sitting is closed. The sitting is open. I shall now recall the principal phases of the present proceedings. The proceedings in the present case were instituted on 7 December 2020 by the filing on the registry of the court of an application by Indonesia against Australia concerning of dispute over ownership of the Ashmore and the Cartier Island. The court meet today is to hear the oral pleadings submitted by Australia as the respondent. I now call upon the respondent to give their statement to the court. You have the floor, sir, ma'am.
I want to tell our statement about Australia claims. First, we as representative of the Australian side will submit several supporting claims that the Ashmore Island is part of the territory of Australia. First, historical facts recorded in the register of the Governor-General of the Dutch East Indies in 1751 show that this archipelago was managed 400 years ago by road people. East Nusa Tenggara, regarding the ownership status of Pulau Pasir, the Dutch have never claimed the island which lies about 320 kilometers north of the west coast of Australia and 140 kilometers across south of Rhode Island. It belonged to him but belonged to England. There is already evidence that the Dutch once controlled the island, but the Dutch never questioned the island in 1878. 30 in the 1800s, at the time when the British making Ashmore Island belonged to the British, in that year Indonesia was already under the Dutch colonial administration. The Sand Island clustered in the south of Timor Island and route was finally annexed by the British in 1878.
After that, from a modern legal point of view, it is ironic that the Indonesian people who have visited and been active in Ashmore Island for hundreds of years since the 16,000 are not entitled to its ownership. while the British who came to Australia in the century 18 actually has stronger rights. It must be understood that modern law is indeed more concerned with the assertion of legal claims than anything else. If it is true that the British claimed Ashmore Island and the Netherlands didn't raise any objection, then it is clear that Ashmore Island belongs to Australia. In relation to sovereignty over Ashmore Island, until now, the Ashmore Island is under Australian sovereignty.
Okay, the third, the cession agreement for England to Australia on the date 23 July 1931, and the second is Memorandum of Understanding (MOU) between the Government of Indonesia and Australian Government 1974, and Part Agreement between Indonesia and Australia 1997 regarding fishing by traditional Indonesia fishermen zone, Australia exclusive fisheries and continental shelf. Based on this agreement, Indonesia recognized that Ashmore Island and the surrounding seawaters are part of Australian sovereignty, but in accordance with international law of the sea in effect, Australia must respect fishermen traditional Indonesian fishing in the waters around the Ashmore Island to the boundaries set out in the 1974 MOU and 30th Part 1997.
The principle of effectiveness law. According to this principle, state ownership of a territory is determined by its validity, effective national legal regulations in the region. Relation to the exercise of Australian sovereignty over Ashmore Island, since the handover of Ashmore Island from England to Australia in 1931, then in 1938 until 1978, Australia established Ashmore Island as part of the government territory Northern Australia. Furthermore, on August 16, 1983, Australia decided Ashmore Island as Australia's National Nature Reserve Park.
And the last, Your Honor, is various good international jurisprudence issued by the Court International and International Arbitration Court, which contain effective occupation by means of acquiring the territory of a country, such as a decision of the Court of Arbitration in the Palmas Island case between the Netherlands and the United States in 1928, or the International Court of Justice decree regarding the ownership status of Sipadan and Ligitan between Indonesia and Malaysia. Thank you, Your Honor. That's all the statement from Australia.
Thank you. The court will now proceed to a break for the panel of judges to discuss. The sitting will be resumed with the agenda of delivering the decision for the indication of professional measures and the final verdict in the case concerning of dispute over ownership of the Ashmore and the Cartier Island, Indonesia versus Australia. The sitting is adjourned. The sitting is open. The court meet today is to deliver its decision on the request for the indication of professional measures submitted by Indonesia. In the case concerning of dispute over ownership of the Ashmore and the Cartier Island dispute, Indonesia versus Australia. After hearing all of the pleadings delivered by the applicants and the respondents, the panel of judges have discussed in regard to the dispute a quo. We would like to read the professional measures along with the consideration, separate into three main parts. I would like to call Mrs. Elsa, one of the judges from the panel, to read the first consideration.
Thank you, Mr. Ahwal. I will read the first consideration regards to the geographical location of Ashmore and Cartier Island. Cartier Island is 70 kilometers east of Ashmore Reef in the West Sahul region of the Indian Ocean. The island is about 3,000 kilometers off Australia Kimberley coast and 200 kilometers south of the Indonesian island of Roti. Ashmore Reef is situated at 12:20 123:00 and lies some 450 nautical miles west of Darwin, 330 nautical miles north of Broome, and 60 nautical miles south of the Indonesian island of Rod Ashmore Reef, encloses an area of approximately 583 square kilometers. Historically, since 100 years ago, the fishermen from Rud, Sabu, Alor, Flores, Bugis, Buton, and Madura has expanded their explorer into this island. Even there are 16 coconut trees, water research, and so many other things which can be counted as the proof of the activity by Rottendale fishermen can be found on the island. The fact is even harder when it is clearly counted that the distance between Ashmore Reef and Rhode Island, Nusa Tenggara Timur, just around 80 miles, and the distance between the island with North Queensland, Australia is approximately 400 miles. Fan Treewater Resort on the island can be said belongs to the sailor Amarohi, the sailorman who came from Sabu Island. This factor can be one of the reasons why, nowadays, Indonesian fishermen still without any hesitation still do some maritime activities on the related island. Their sense of belonging to the past still attached among these fishermen and claim this island was once conquered and managed by their ancestors, based on the natural heritage trust by the Australian government. Ashmore Reef contains two extensive lagoons, several channels, carbonate and flats, shifting sand cays, an extensive reef flat, and three vegetated islands in the east, middle, and west island. And on the reef fronts of the rivers are punctured with spur and groove formation and have a high diversity of robust corals, and also the crays are legal dominate with the reef flats street with lines of coral rubble, and on the with the reef flat street with lines of coral rubble, and on the biological diversity case. The Ashmore Reef support district assembles of benthic habitat and pelagic communities. This reef also supports the greatest number of reef-building coral species of any reef are on the western Australian coast. There are also particularly high numbers of mollusks and fish species in the rivers, and the region has particular global significance in terms of its sea snake diversity and density. This reserve also supports a high population of seabirds, many of which are migratory and typically have their breeding sites on small isolated islands. The Ashmore Islands are regarded as supporting some of the important seabirds rockies on the northwest south, and a survey by the Museum of Western Australia in 1979 1997 brought the total number of recorded fish species in Ashmore Reef to 1,907 species, which indicate the Ashmore Reef has the most diverse marine fish fauna of any region in Western Australia. I would like to call Ms. Patricia, one of the judges, to deliver the second consideration.
Thank you, Ms. Elsa. I will now continue to read the second consideration regards to the historical data mentioned by both parties. Like its maritime borders, along with some countries in the region, Indonesia is obviously also have some maritime border with Australia as one of Indonesia's neighbor in the Pacific area. It is counted that Indonesia and Australia share a common maritime border in the area of Indian Ocean between Christmas Island and the island of Java. The boundary of maritime dispute of Indonesia and Australia has three separated segments. The first is between Australia, Indonesia, and Papua New Guinea. The second segment runs westward from the point where the territorial waters of the two countries touch the western limits of East Timor's territorial waters claimed in the Indian Ocean. And the third is between the Australian external territory of Christmas Island and the Indonesia island of Java. In Indian Ocean, in the early of 2003, there are also some highlighted event in the Ashmore Reef which successfully make both countries have to tighten their seat belt in order to prevent any further conflict because they dispute. In 2003, Australia decided to launch a policy or agreement to do some profit sharing based on the natural resource contained in Celah Timor with Timor Timor, or even any kind of activities of fishing by the Indonesian fishermen within Ashmore Reef start from July 2003. This one-sided action that has been taken by Australia got a critical comment from Indonesia's government because they argue Australia has to bilateral talk between the countries considering the island, that time still also under Indonesia's management. The fault line of Australia claim on the island is moreover has been proven by the fact of what is called as ZEE or Zone Economic Exclusive, wherein every 200 mil of the maritime line, the location of Ashmore Reef is in the area of 60 mil of Rhode Island, the region of Rondao, Nusa Tenggara Timur. This is a crucial issue for Indonesia because the maritime border line is a strategic, also a sensitive issue. Besides, it is related to the sovereignty, sovereign rights, and jurisdictions. These elements of maritime border of each country in this world also has been controlled by UNCLOS 1982 or United Nations Convention on the Law of the Sea, which seemingly based on this case, the agreement among Indonesia and Australia has to be re-explained by UNCLOS, moreover by the first number 51, where basically every nations have to protect and acknowledge the rights of traditional law of one country which has been a long run. That's it, and now I would call Ms. Puspa, one of the judges, to deliver the last consideration.
Thank you, Ms. Patricia. I will continue to read the last considerations regards to legal evidence from Indonesia and Australia. Past actions by Indonesia and Australian government. In order to tackle the related issue, there are obviously some of the past actions that has been taken and done by both Indonesian and Australian government. Best past actions are first, MOU or Memorandum of Understanding Box 1974. Memorandum of Understanding, or it's usually known in the international agreement to highlight some events about some agreements which have been succeeded by several related actors, which then be used for the rules of agreement that will be met as the core of the implementation of agreement. In November 7, 1974, there is an MOU that agreed by Indonesian and Australian government in regard of this issue, or it's mostly known as Memorandum of Understanding between the government of Australia and the government of Republic of Indonesia regarding the operations of Indonesia traditional fishermen in areas of Australia, exclusive fishing zone and continental shelf, which rule the terms of fishing and another rules in Ashmore Reef. This MOU also provides Australia with a tool to manage access to its waters, while for Indonesia, it enables Indonesian traditional fishers to continue their customary practice and target species such as tripang, trochus, abalone, and sponges. This
MOU seems cannot stay less long, recognizing that in 1993 Australia declared a marine protected area around Ashmore Island, and in 2000 around Cartier Island. In order to settle this matter, in 2009 the Working Group on Marine Affairs and Fisher agreed to a roadmap for MOU box cooperative management. The key components of the roadmap of the MOU are A. Research terms of reference and a research program, B. Management measures and options, C. Socioeconomic and livelihood aspects, D. Training and capacity building needs, and for the last consultative process with stakeholders and consultations with traditional fisher, taking into account their concerns, including the using of technology for fishing process. Second, Perth Treaty March 14, 1997. This treaty is also a treaty that has been taken by Indonesian and Australian government. Under the 1997 Perth Treaty, there are areas of overlapping jurisdictions, including to explore for petroleum, and Indonesia exercises water column jurisdictions, including fishing rights, in the Perth Treaty area. But seemingly, this treaty has not been enforced. And then the Australian government acts consistently with obligations under the Perth Treaty pending its entry into force. And this treaty contains some number of obligations, such as A. Article 7, areas of overlapping jurisdictions, requires that Australia give Indonesia 3 months notice of the proposed grant of exploration or exploitation rights in the Perth Treaty area. B. Article 9, exploitation of certain seabed deposits, directs the parties to seek agreement on the most effective means exploiting and equitably sharing any hydrocarbon deposit that straddle the maritime boundaries described in the treaty. With that past agreement between Indonesia and Australia, which has been both agreement, even this claim has been agreed by Indonesian military of maritime area, and both of the legal evidence are a permanent legal force stating the ownership of the island belongs to Australia, and these evidences are truly fact and has been admitted by Indonesia and Australia. Thank you.
With all of the consideration having delivered, the court has concluded and decided. Well, as we can see, the claim of Ashmore between Indonesia and Australia already facing so many days of a battle. But this long-run battle finally shown the result of Australian government as the winner of the claim. What makes Australia is finally claim and winning this island is the core of historical background. When British colony gave this island to the Australian side in 1931, and after that, it is claimed as the part of Western Australia, while Indonesia is failed to claim because the bias proof, which just rely on the history of Indonesian fishermen from Rhode Island has been staying and doing customary activities back to 400 years ago. The ownership of the Ashmore and Cartier Island still belongs to Australia. The court considers the Australian territory in the Ashmore and Cartier Island based on proclaimed reserve on 16 August 1983. Referring to the Conservation Act 1975, the court considers the 1974 MOU agreement as a permanent legal force, stating the ownership of the island belongs to Australia. On the other hand, Indonesian people, specifically traditional fishermen, still have the authority to search for their livings from the island, with few requirements, according to the 1974 MOU agreement, referring to the 1982 UNCLOS and Sipadan and Ligitan jurisprudence, with an additional explanation of the definition in one of the points of the agreement, related to the definition of traditional fishermen. Specified into traditional fishermen are fishermen who use traditional wind-powered boats and fishing around the coast. I think that's enough from us, judges. The text of the order is available from today in TypeScript. It will be available shortly on the court's website, as well as the print text. As the court has no further business since today forward, I declare the sitting closed. That's all from us. Thank you for your attention. Wassalamualaikum warahmatullahi wabarakatuh.